Chairman Metz, members of the Senate LEOBoR Task Force. On behalf of the Rhode Island Public Defender, we first wish to thank Senator Metz for his leadership on this important issue and for his invitation to provide the following information to the task force at its meeting on Wednesday, November the 18th. Prior commitment prevents me from attending in real time, remotely, but in real time. But I was afforded the opportunity to provide this information to you all via recording, and it really is a pleasure to do so. First, let me tell you a little bit about myself. My name is Michael DiLauro. It's been my honor and privilege to be employed by the Rhode Island Public Defender since March the 2nd, 1981. My career at the Public Defender's Office has been fulfilling, rewarding, and interesting, to say the least. For the first half of my career, I was a regular line public defender. I tried cases, I went to court, pled cases, representing indigent folks accused of crime. The second half of my career is where I've come to know many of you on the task force as a policy advocate, having the opportunity to talk to all of you about criminal justice issues, where, again, I've come to know many of you. So on my behalf and more importantly, on my office's behalf, we want to thank you for the opportunity to present this information to you. By way of background, for those of you who don't know, the statutorily prescribed mission of the public defender is to provide high-quality criminal defense and related services to indigents accused of crime in all Rhode Island state courts. And in looking at the mission of this task force and what you are called upon to do, the work that we do in the Public Defender's Office, as required by state law, is not directly related to much of the work that is being undertaken by this group. Let me just give you a couple of examples. You've been talking about things like the composition of the hearing panel that passes upon or adjudicates complaints made against officers. You've talked about and heard presentations on whether or not it might be a good idea to expand summary and unreviewable discipline for officers for a period of beyond 2 days. You've also talked about things like streamlining procedures while protecting procedural due process. While all of these things, of course, are of interest to the public defender, and we take note of the things that you've been considering, these things are not directly related to the work that we do in the Public Defender's Office. But one of the things that you have been considering and have heard presentations on, which is of great interest to the Public Defender's Office, is the issue of transparency. And in particular, the transparency of records pertaining to allegations of law enforcement officer misconduct. That information and the information that you have been presented in the course of your work, this is of great interest to the Rhode Island Public Defender. Information relating to allegations of and investigation into those allegations of law enforcement officer misconduct are known in the criminal procedure context as Giglio material, named after a United States Supreme Court decision many years ago, which talked about having access to this type of information as part of what is required by Brady versus Maryland. Brady versus Maryland is another United States Supreme Court decision that says that information favorable to the accused must be provided to defense counsel by the state, by the government, in the context of a criminal case. Giglio material has been recognized, as I said, by both the United States and Rhode Island Supreme Courts, and they have clearly stated in a series of cases over the course of decades that a defendant may have access to this information and, when appropriate, may be able to use it in his or her defense at trial. These cases are grounded in the procedural due process requirements of the 5th and 14th Amendments to the United States Constitution, as well as Article 1, Section 10 of Rhode Island Constitution. And although the law is clear that this information should be accessible to the defense in criminal cases, while that law is clear, it has been the experience of the public defender that the appropriate mechanisms necessary to ensure access to this information, both by the court and by counsel, in a complete and timely fashion, is in need of improvement. So, talking about transparency in this context and transparency regarding this type of information, the public defender believes that this problem may be addressed. What I'm talking about is this transparency issue that I've talked about regarding this information, this Giglio material, may be addressed, at least in part, by standardized, uniform, and consistent statewide policies and procedures that assist law enforcement in determining what and what is not Giglio material, the manner in which this information should be collected, compiled, and stored, and finally, the predicates necessary for disclosure. In that regard, some recent history may be of assistance to you. And again, rather than reinvent the wheel, I would respectfully suggest to you that it might be of assistance to you to look at the work being done by a similar Senate task force created a couple of years ago. Some of you on this task force, in fact, Mr. LEOBoR, and I can't recall who else, are also members of this group as well. So, again, by way of background, beginning on February the 16th, 2018, and as part of its legislative efforts, the public defender directed an APA request to 44 state and municipal law enforcement agencies requesting, quote, your agency's general order and or written policy describing its protocol for responding to requests made by the defendant through the applicable prosecutorial entity, including but not limited to the Department of Attorney General, city or town solicitor, or other prosecutorial entity or persons responsible for the prosecution of criminal cases in court, close parentheses. This for the production of discoverable material in criminal cases. The request went on to say that this includes requests made pursuant to Rule 16 of the District, Family, or Superior Court Rules of Criminal Procedure, or the exculpatory evidence, parentheses, Brady doctrine. And as I've stated, both the United States and Rhode Island Supreme Courts have consistently stated that Giglio material involving allegations of law enforcement officers' misconduct are included in the definition of exculpatory evidence, and disclosure of which is required pursuant to the Brady doctrine. I have given counsel to the task force a summary of the of that APRA request, so you can see where we were at least as of May of 2018 when the APRA request ended. My recollection is we received responses from all 44 Rhode Island law enforcement entities. You can see, as I said, a summary of it in the handouts that Mr. Bazillion can make available to you. So, as a result of the public defender's efforts, and with the support of the Attorney General, the Senate created the Special Task Force to investigate and make recommendations for any changes to the law, court rules, or the policies and procedures currently in place to enhance the timely and complete disclosure of discoverable material in criminal cases. That group was created by Senate Resolution number 2018 R328, and that group is made up of a very broad cross-section of Rhode Island criminal justice stakeholders. We began our work in January of 2019 and met on a regular basis until our last meeting on February the 24th, 2020, when our work was interrupted by the COVID-19 pandemic. Let me say that although I am the public defender's designee to the Senate Discovery Task Force, and am honored to be a co-chair with the Attorney General's designee, Assistant Attorney General Patrick Youngs, that in no way, shape, or form am I here to talk about to say that that I'm speaking for the Senate's Discovery Task Force. I'm speaking today for the public defender. That being said, I think it's appropriate for me to tell you a little bit about some of the areas where the Senate Discovery Task Force has reached consensus, because it is very similar to some of the things that this group is thinking about and considering regarding transparency of law enforcement records pertaining to allegations and investigations of law enforcement officer misconduct. So as I said, we began our meetings in January of 2019, shortly after Attorney General Nerona took office. His office has played a tremendous leadership role in that regard, and some of the things that have been accomplished, all of the things really that have been accomplished that I'm going to tell you some about, have been as a result of his leadership and his designee's leadership. So I'm just going to tell you a couple of things where we have reached consensus that overlap with the work that this group is doing. The task force has reached consensus on a broad variety of sensible reforms and recommendations that would enhance the timely and complete disclosure of discoverable material in criminal cases, and including, as I said, Giglio material. For example, at its meetings on December the 2nd, 2019, and January the 13th, 2020, the task force reached consensus that when it comes to Giglio material relating to allegations of law enforcement officer misconduct, quote, it would be beneficial for Rhode Island law enforcement to have statewide uniform standardized policies and procedures in this area, unquote. The task force at that time and thereafter also had begun collecting a variety of model policies and those in place in other states, as well as working with the Rhode Island Police Accreditation Commission, or RIPAC, to design one for Rhode Island law enforcement agencies. I have given the legislative counsel Bazillion and asked him to distribute the approved minutes of our task force meetings on December the 2nd, 2019 and January 13th, 2020, so that you can see where we in fact did reach consensus. As I said, our task force also received model policies and policies actually in place in several different states. We looked at in model policy promulgated by the International Association of Chiefs of Police, by Lexipol, which is as I understand, a risk sharing entity for law enforcement, and we looked at the Lexipol policy in this area, a policy in effect in the state of Utah, and my recollection too is that we had also begun to engage with the Rhode Island Police Accreditation Commission to design a model policy for use in Rhode Island. So again, there's a lot of overlap in the work being done by our group, and areas where, in fact, there was consensus was reached regarding the benefits of having a uniform, standardized policy in place, again, regarding the collection, compiling, definition, and disclosure of Brady material generally, and Giglio material in particular, that I think are worth this group, your group, taking a look at. The public defender believes that, as has been the case with eyewitness identification and the electronic recording of custodial interrogations, where similar legislatively created bodies of criminal justice stakeholders made really high quality recommendations or best practices that have been adopted by every Rhode Island law enforcement agency, and those two in particular stand out in my mind: the eyewitness identification improvement task force and the recording custodial interrogations task force made a series of recommendations, again, that is our understanding have been through the standardization and policy area have been adopted by every Rhode Island law enforcement agency, that something like this is can address some of the issues that you folks have been considering for the last few months. Finally, I would suggest to you, I gave you, when you're talking about Giglio material, I gave you two Rhode Island Supreme Court decisions. They're really the same case, but the decisions are named State versus Beaumere. And what happened in the Beaumere case, just to show you what Giglio material entails, as our Supreme Court has discussed, the Rhode Island Supreme Court has discussed. In the Beaumere case, the defense counsel was prohibited by the trial judge from going into or asking the lead detective in that case about investigations into allegations of misconduct on his part. And after Mr. Beaumere was convicted, he appealed to the Rhode Island Supreme Court, and the Rhode Island Supreme Court overturned the conviction, saying that this was a relevant and important area of cross-examination because the officer, and even though these allegations had nothing to do with the case that was on trial, the Supreme Court overturned the conviction because it found that it was relevant cross-examination that should have been permitted because these ongoing allegations may have caused the officer to shade his testimony or try to curry favor with his superiors, and therefore would embellish perhaps his testimony in the case that was on trial. I think it's helpful for you to take a look at that case, take a look at the other materials that I've provided you with, the minutes that I mentioned from the 2 Discovery Task Force meetings, the model policies that our group was considering, and the other information that I've provided to Legislative Counsel. Unfortunately, I can't take questions from you, but my contact information, I would ask, I know Senator Metz has it, and I know Mr. Basilian has it. Please feel free to call me, reach out to me at any time, email, cell phone, whatever is best for you, and I'll be happy to try and answer any questions that you might have. I'll just conclude by saying thank you for affording the public defender this opportunity to address your, hopefully assist in the process you've undertaken. And thank you again to Senator Metz for inviting us to participate and share our perspectives with you here today. Thank you very much.